Do you enjoy competition? Do you enjoy the hunt? Do you enjoy a game of chance? For example, do you buy a lottery ticket from time to time, especially when it's one of those big high numbers? Or do you play blackjack in a casino? Many of the personal injury lawyers and claims professionals can identify with this. How do I know? Because I was a personal injury lawyer. It's not what I do now, but it did lead me to a point where I could analyze what we're going to talk about today. So, isn't a negligence case just a gamble? Isn't it like buying a ticket to see if you won the lottery? And isn't handling a case as a lawyer or an adjuster a zero-sum game? Isn't there just one winner and one loser? How about if I was to tell you that that is not the case? That a case shouldn't be a gamble, and it shouldn't be treated as a gamble, and that lawyers should never gamble with their clients' cases, nor should the adjusters or claims professional handling their clients' cases. Cases are sacred entrustments. That's how I see it, and that's how I propose that you should look at it. Lawyers should remove chance from the outcome and seek certainty of results. Well, if that's the case, what is it with all the advertising we see for accident cases? You're assaulted when you're driving on the road these days by these huge billboards, proclaiming and promising the best representation and big results and millions of dollars collected if you use a certain law firm. And all I can think about is how much our profession has changed. Believe it or not, there was a time, and I can remember it, when advertising by lawyers was not allowed at all. And then there came a time when advertising was allowed, but it was only factual information that was allowed. Name, address, phone number. And I don't know when it all happened, but it's now evolved into this all-out assault on people's senses. Now it's about money and winning and chance and gambling. It seems as if there's no restrictions at all. I mean, can we be far from billboards that claim criminal legal services that say, robbery? No big deal. No problem. We can steal victory for you. Hire us. Can that be far off? I don't know. Maybe it's here already. The signs, the billboards are lit up like Las Vegas hotels. Flashing signs, flashing lights, multicolored, pictures of the lawyers, pictures of clients, big dollar signs. These signs evoke gambling. To me, it's just incredible. And you know something funny? These signs are so distracting that I actually wonder how many accidents they in themselves have caused just by the way they sit on that highway and distract drivers. So should your case be looked at like a gamble? Should your lawyer be advertising like the sign for Mega Millions or Powerball? Should you be the lawyer who does that? Or for that matter, should you be the lawyer who treats his client's case as a gambler? For that matter, should you, the lawyer, be a gambler? Does this kind of mentality serve justice in any way? And shouldn't lawyers be about serving justice? There is a lot to unpack here. And in this podcast, we're going to do just that. I am your lawyer, PI lawyer, turned mediator, Tony Mascolo. It took me 40 years in the business of personal injury, but I am now gone from the dark side to the other side. I have lived your life, and I had the same type of cases you do. I struggled with the hurdles of this business. I worked with attorneys, claims professional, judges, and juries. I have won cases and I have lost cases. But one thing I never did was I never gambled on a client's case. Never, ever. It was not my money to gamble with. Now, truth be told, I do gamble. And when I do it with my own money. So I have bought lottery tickets. I have played poker with my friends. I have gone and played blackjack in a casino. But when I've done those things, I've done it with my own money, understanding the risks that were involved and never wanting to cause hurt to anybody. So I propose that if you keep true to your lawyer oath of putting your client's interests first, you will never be the lawyer/gambler that is so often portrayed in those larger-than-life ads on the side of the highway. Now, does this mean that you can never take a chance in a case or on a particular point in a case? No. It only means that the chance you take in a case should be an educated chance with the understanding and full authority of the client. No chance should be taken because you, the lawyer or the adjuster, want to gamble. You need to remember that clients only have one chance at gaining fair and just compensation for their case or fair and just resolution to their case. Now, a lawyer or an adjuster, well, you can have hundreds of cases representing different clients with varying degrees of possible successes or losses, depending on the facts and the law. So you as a lawyer, you can afford to lose 3 cases. If you win one where you earn, where the jury gives you $5 million. So what? You've earned your money, but those other cases that you tried and lost or gambled on, well, those people are never, ever going to be fairly compensated. So some lawyers may feel that they have so many cases to lose that if you lose a couple, it's not a big deal because you'll make up your fee on other cases. But I propose that this is the wrong way to look at your caseload and look at your cases. Again, your client only has one case to be compensated, and that should always be the paramount thought in your attorney brain. To my way of thinking, the best lawyers, the ones who represent their clients in the best possible way, never forget this. And I propose that this is the only way to practice in personal injury work. Now you may be wondering, what does this have to do with mediation? Well, let's look at what having a legal system that redresses and addresses negligence to another really does. Legal cases, the ability to get a perceived wrong corrected in the law and under the law, well, that creates hope. So in that sense, it's just like the lottery ticket that you may buy. The lottery ticket creates hope. A case can create that same type of hope. And that creation of hope, it creates a certainty that a gambler usually does not have in a casino or in a lottery ticket, or even if you're a lawyer and you're picking a jury. So what do I mean by that? Well, if one has hope and there is a system of justice, then the injured person will rely on that and not resort to barbaric acts for justice. No eye for an eye. That is just so Old Testament. Mediation is part of the New Testament approach. It embraces the relationship and decency of human beings. It leads to fair and just results that all can live with. The wrong can be righted. The insurance carrier pays what the case is worth, no more and no less. Now, you may be asking, why should you, the lawyer, or you, the adjuster, look at things this way? Because any other way is just a gamble. And we know that gambling is not what a lawyer or claims professional should be doing if he has his client's best interest in mind. Now, if this kind of approach, which I admit is different than what you might hear anywhere else, if this kind of approach interests you and you want to know more, then visit with me at www.smarttomediate.com/book a call. Book a call with me and take a chance on learning how to manage your caseload better. Don't gamble on your cases and caseload. Produce the certainty your clients and you deserve. Does that mean there's no uncertainty in mediation? No, it most certainly does not. What it means is that the uncertainty is minimized and the certainty is maximized. That is what most professional gamblers know. Professional gamblers are distinguished from amateur gamblers. Professional gamblers know you don't just walk into a casino and play. That is a recipe for disaster. More likely than not, you are not going to win. The professional gambler, like the professional lawyer, knows that you'll first study the game. You'll learn all the rules. You know, if you look at the opulence of a casino, you should not just be in wonderment. You should be asking, why is the casino making so much money? And the answer to that is casinos are not in the business of fairness. They are in the business of making money. They are in the business of taking your money. The odds of games are manipulated in so many ways, and it's legal to do that. If you understand one thing about gambling, understand this. When you play in the casino or anything else, The true odds are never paid out. You can never win. I have studied gambling. I know this, and I understand the gambler's mind and the casinos. For many years, I've studied them. I have likewise studied the lawyer's mind in regard to personal injury litigation. The answer is that casinos are not in the business of fairness. They are in the business of making money. But you, as a lawyer, you, as a claims adjuster, you are in the business of fairness. Your business is not only about making money. And there is the rub, okay? How do you balance those two things? I propose to you that mediation is a way of balancing all of that. But remember, in gambling, the odds of games are manipulated in so many ways, and it's legal to do that. As I told you, true odds are never paid out, and you need to trust me on this. I have studied gambling. I have studied the gambler's mind, and I have studied casinos and how they operate for many years. I had a reason to do that, something I'll get into in another mediation, but I have also likewise studied the lawyer's mind in regard to personal injury litigation. And I've studied how the courts work in regard to personal injury litigation, and I've lived that life. I have had the opportunity to work with gamblers and change the way they gamble. I've helped them. I've taught them how to maximize their wins and minimize their losses. Sometimes that's the only way to help someone, is to teach them and educate them. And then they have to take it from there. I'd like to think I've helped save them from themselves, and I've helped save them and those who they love. Again, what does this have to do with mediation? Well, I believe that mediation can do the same for the lawyer and adjuster. Mediation can help educate you, and it will maximize your wins and minimize your losses. Now, isn't that a good thing? You need to understand that the mathematics in any game, in a casino or in anything in life, is important to know. So you need to understand the mathematics of a mediation. The mathematics of a mediation are the probability of a fair resolution by using learned techniques by a skilled mediator, one who knows your business and knows your life, someone like me. The only hope to win in a casino on any consistent basis is to remove the luck aspect and rely on knowledge of the game. The only way to win for your client as a lawyer is to be educated and smart. Remove luck from the equation. Just like in a casino, it is smart to know the good bets to make and the smart plays that make and reduce the house edge. This way, it becomes like a game of chess. That is how you should look at a mediation. Mediation is a move and a counter move, and that results in a resolution. I propose that you aren't doing your best lawyering for a client if you are gambling a client's only chance for fair and just compensation. When you gamble a client's only chance, I think a lawyer is being selfish and a claims adjuster is being selfish and not thinking about their client's best interest. Your job as a lawyer or even a claims professional is to reduce the uncertainty of result, and mediation is one of the best ways to do that. If this interests you and you want to hear more, or you'd just like to have a good conversation about this, well, one, subscribe to my podcast, and I would ask you to even share it with your coworkers. So I need you to like, subscribe, and share. I think you know the ritual on that. And I also want to remind you to go to www.smarttomediate.com/book a call to get clarity and certainty in your work going forward from me and what I've learned in all the years that I have practiced. As I was preparing this podcast episode for Wednesday's release, something amazing happened. Something that involves mediation, the whole idea of gambling, and the results that can happen from good preparation and maybe from bad preparation. So what happened was this. You probably heard about it at this point. It's 24 hours later that I'm getting around to talking about this because I finished my podcast episode. But then I decided we needed to talk about this. It relates directly to what we've been talking about in this podcast. So we all witnessed a meeting in the Oval Office between the Ukrainian President Zelenskyy and our President Donald Trump. Others present included our VP and our Secretary of State. This meeting was part of the efforts of our President Donald Trump to broker a peace between Russia and Ukraine and to bring an end to the war of destruction between the two countries to bring peace. This carefully orchestrated meeting, which occurred only after more than a week of discussions in the Ukraine and in Germany between American officials, General Kellogg, tried to bring us to the point where we could have this meeting in the Oval Office. And initially it looked pretty promising. It was streamed live for the first 40 minutes of this hour meeting. It looked like it would be nothing more than a document signing, a lot of handshakes. Step one would be completed, and we could go on to step two, which was now to talk some more with Russia and get the entire deal done. But then something changed. The meeting went sideways, which often happens in mediations, and the meeting abruptly ended with no signing of anything, and the Ukraine delegation unceremoniously asked to leave the White House. What went wrong? This mediation, if that's what we're going to call it, had such wide-ranging implications for world peace. How could it go wrong? Let's look at this situation from a mediation standpoint. The mediator in this situation, our president, Donald Trump, was in a position of being just like any other mediator. And we all know that for a mediator, the rules are fair, be impartial, maintain confidentiality, maintain neutrality, but allow self-determination. A mediator also provides a safe environment and a quality process. For the parties, it should be noted that coming to a mediation or to the process of mediation should be voluntary and never ever compelled. Mediation doesn't work if it's compelled. Arbitration is compelling, but mediation is voluntary. So mediation has been described by various authors and institutions. I'll give you three meanings that I plucked out. One, in a mediation, the parties involved in a conflict voluntarily work with an impartial third party who controls the meeting process in an effort to reach a mutually agreeable solution. It's the parties that control the decision making. The mediator controls the meeting process. Another one would be that mediation is usually a private, voluntary, informal, but structured process where the mediator assists the participants in resolving their dispute in a manner acceptable to all. And the last definition is probably the one that I will adhere to the most and see as relevant to the world that I work in. And it's this: mediation is an imperfect process that employs an imperfect third person, the mediator, in this case Donald Trump, to help imperfect people, Zelenskyy and Putin, come to an imperfect agreement in an imperfect world. And I think the beauty of mediation is that it deals in this imperfect world and may come up with results that are imperfect but are necessary and allow us all to move forward. So I believe that this last part is really what happened at this first step to this peace meeting. Step one, as I looked at it, was designed to give the Ukraine an American presence by allowing the U.S. to mine precious minerals. This U.S. involvement, although great for America, it violated some of the rules. Impartiality, for one, neutrality. The mediator, the U.S., now had an interest in the outcome. Now, we could argue that, of course, everyone has an interest in peace, but this was brought up to the level of in-your-face, a direct and a recent addition to the process. I'm not here to pass moral judgment or any kind of judgment on whether this was smart or not. I just know that it played a role in probably what happened. It created an interest that was diametrically opposed to the Russian interests. I can't imagine that the Russians would want a mediator that now had an interest in the outcome. Again, we all know there were interests all around, but this became very direct and in your face by this process. So some could argue, and would argue here, in fact, that I'm wrong, that this was genius on the part of our president, because it would be the one roadblock the Russians would respect and never violate: American presence in the region. Yet I believe that even had it passed muster at this meeting with Zelenskyy, it would have met with great resistance in Russia and with the Russian delegation. They, in my opinion, would have seen this move as a violation of impartiality, and it would have made it much more difficult for the mediation and the meeting of the minds of all sides here and to come to a resolution. Another look at America or Trump as the mediator provides some more clues as to what happened in this breakdown. Trump had to appear impartial. In reality, he should absolutely be impartial to be a good mediator. But let's, for the sake of argument, say that he was impartial. Any attempt by the Ukrainian President Zelenskyy to have Trump or America appear to be more on the side of the Ukraine would again have been met by skepticism by Russia. So Trump had to stop any discussion that would make it look like America and Trump were not impartial. The world needed to see an unbiased America. Trump obviously was aware of that. Our delegation was aware of that. It doesn't appear that Zelenskyy got that message before. The process was flawed and was not thought out correctly to prevent this from surfacing. The metals deal had already put the relationship under the microscope, and any agreement with additional Ukrainian requests for, and I think the word he used was security, and we should understand that I think he means by security, he wants NATO membership. Any agreement with Ukrainian requests at this meeting would have been a fatal blow to the deal. It would not have ever happened on the other end. What is interesting to me here is that if you listen to it, you'll see that Trump used the word gamble. He accused Zelenskyy of gambling with the prospect of World War III, gambling with the lives of the people in his country. And this, of course, is exactly what we have been talking about earlier in this podcast. That you're a gambler, and what should you do as a gambler if you're a participant in a mediation? You shouldn't be gambling with your clients' interests and rights. So are you a gambler at the mediation? So Trump apparently saw Zelenskyy as a gambler, not a resolver. Someone who was taking his own client's interests and maybe his own interests and taking a risk, trusting things to luck. Trump doesn't want to leave anything to luck. Trump wants to solve the problem. Trump had to confront Zelenskyy with this gambling accusation. But, again, this was a violation of what we would call neutrality mediation standards. This one really involved more confidentiality because this kind of discussion should have happened behind doors. You don't accuse and yell and chastise the party at the mediation in front of the world to see, because that's just going to harden positions and make it more difficult. The wonders of Zoom would have been great to use here, because each could have been in a breakout room, away from the other, away from the world, and they could have had some private discussions, and when all was worked out and figured out, they could have come out and discussed this in front of the world. I would say that the announcement in the Oval Office that day was premature. It should not have been made without the knowledge of the result. Sometimes doing things partially can actually hurt the final result. So I do think the process was flawed and really doomed from the start. I think they tried to make it look like a mediated process when in reality it was not. And I don't think it was a setup either. I think it was a flawed process. I think there was great power imbalances here that came into play. And one of the roles of a mediator, we will talk about this more in the future, is that mediators need to figure out how to equal up power imbalances. Okay, not so much in personal injury cases, but in other areas of mediation. And here, there were some very obvious power imbalances. The Ukraine is not on an equal power balance with Russia, nor is the Ukraine on an equal power balance with our country. Ukraine is propped up with a lot of support from NATO and America, and this is what kind of keeps them in the game. This power imbalance came into play here. I believe I saw real fear in Zelenskyy's face. I don't know what prompted it to be. I don't know why he felt that way. But I felt the power imbalance. I felt that he felt the power imbalance and had felt it had gone too far and that his weakness would show because it was being all recorded in front of the world to the Russians. And that power imbalance would not serve him or his people well. That's my opinion. I would have handled this mediation process differently. But listen, I'm not dealing with world consequences to the cases that I do. I'm dealing with litigated cases between parties that don't have world implications, but still are very important to the parties involved. As an American who wants peace, I could see the end result of the minerals deal. It would put us in the Ukraine and act as a barrier to Russian aggression. But for the life of me, at this point, now again, I didn't have any discussions with Russia, I did not see how this was going to sit well with Russia. It remains to be seen. I believe that we're going to find out what the result of this is going forward. I believe that the Ukraine really will have to capitulate at this point, and that power imbalance is going to be very real and out front, and I believe that they're going to have to do this or there will be no peace. Now, the part that I don't know is how Europe is going to step up into this void that now exists, and maybe that will create another environment for peace. I hope that all the parties here know what they are doing. This is not a regular mediation. It's difficult here to avoid the landmines that threaten to blow up the deal and maybe the world with every step that everyone seems to take. It's interesting to me that the fate of the world rests in the hands of those that seek, at least outwardly, a mediated result, albeit an imperfect mediation in an imperfect world between imperfect parties that is going to lead probably to an imperfect result. Boy, this is how the world works. To see mediation play on a world stage like this, right when we're talking about it, is incredible. Here's my takeaway. It's not an easy job to be a mediator. You're going to be second-guessed. It's very difficult to mediate results that are good for all involved. It's usually imperfect. But here's what I hope for. I hope that this one time we have a mediation that involves perfect mediator, perfectly positioned parties, and a perfect result. Don't know if it can be done, but I know it is what I hope for.